Good morning, everybody, and welcome to the First District Court of Appeals. We have several cases on the docket this morning.
早上好，欢迎来到第一上诉地区上诉法院。今天早上我们有几个案件在审理日程上。
And the first case this morning will be He versus Baker.
第一个案件是和诉 Baker。
And we have an interpreter present for Mr. He.
我们有翻译在场，为何先生翻译。
Ms. Quinn, I will ask you to please raise your right hand. I will administer an oath to you for interpretation. Do you solemnly?
请举起你的右手，我会让你就进行法庭翻译进行宣誓。
Mr. He, you do not need to take the oath.
何先生，您不用发誓。
Ms. Quinn, do you solemnly swear or affirm that you will interpret accurately?
请女士，你庄严宣誓，你将会准确地进行翻译，
Completely and impartially,
完整不偏倚地进行翻译，
using your best skill and judgment,
使用你最好的尽你所能，使用你最好的判断能力，
in accordance with the standards prescribed by law,
遵守法律规定的标准，
and follow all official guidelines established by this court
并且遵守所有由本庭设定的指南，
for legal interpreting or translating,
进行法庭口译或者笔译，
and discharge all of the solemn duties
履行所有庄严的职责
and obligations of legal interpretation and translation.
和进行法律口译笔译的所有的责任。
And if so, please answer, I do.
如果是的话，请回答我发誓。 Yes, I do.
Thank
是的，
you.
我发誓。谢谢。
Mr. He, you have 15 minutes this morning.
何先生，您今天早上一共有15分钟的时间，
And I will keep track of the time.
然后我会保持记录时间。
And you may make any argument that you would like to make to this court.
你可以对本庭做出任何你想要进行的争辩。
And Mr. He, you may proceed.
那么何先生，您现在可以开始了。
现在可以说话了吧？
Can I speak now?
Yes.
可以。
我的问题是，我上次给那个贝克先生，请他安装我的那个暖气在地下室。
My question is, I had requested Mr. Baker to install a furnace in my basement.
时间是17年11月5号，
The time was November 5th, 2017.
签了合同，
We signed a contract.
他同意装那个 Goodman furnace，
He agreed to install a Goodman furnace.
是那个承包商那个 Baker， 他要承装那个 Goodman furnace 在我的 basement。
The contractor, Mr. Baker, he agreed to install a Goodman furnace in my basement.
他装了那个 basement， 收我1900块钱现金，2年的服务。
He installed in the basement for $1,900, including the service fee.
他后来改装，私下没有经过我的同意，私下改装了是那个 GMC furnace 在 basement。
Later, without my permission, he changed to install the GMC furnace in my basement.
这个在初审法院他已经承认。
Excuse me, Mr. He. 抱歉，何先生。He installed this without my permission, and he did this on his own.
现在可以说了吧？
Could I speak now? Yes.
Yes.
他就是改装了，私下改装，我们没有同意。他就是后来我的访客发现，他的房子装了以后没有热，他再打电话给我。
He changed this on his own without my permission, and I didn't know this until my tenant realized the house was not warm, that they called me. Then I know.
后来我才去了 basement， 才发现他改装了，不是那个 Goodman， 是那个 GMC。
So later, when I went down to the basement, I found out that he had changed from Goodman furnace to GMC furnace.
这就是说，他没有按照合同执行这个安装这个产品，他自己改装了，但就是违反合同法了，他已经。
So that means he did not perform according to the contract. He changed it to another furnace. That means he already had breached the contract.
后来装了以后，他去打电话给他修，他都没有修好。
After the installment, I made a called him to go do the repair, and the repair was not done properly.
后来我请了2位不同的专业公司去看，还说他是 exactly 是那个GMC， 不是 Goodman。
So later, when I invited 2 different professional companies to go take a look, and realized that was not a Goodman furnace, it was GMC. It was not exactly a Goodman furnace, it was a GMC.
这就是说，初审法院是错误的判决，但是我是这个案件我是很冤枉的。他收了我的钱，没有进行那个合同，这个我要申诉，我要上诉。
So this means the trial court had granted the wrong judgment. I was wrong in this case. So that's why I wanted to appeal. I wanted to appeal for this.
他这个要负全部的责任，因为没有按照合同法进行这个合同，他这个 Mr. Baker 一定要负全部的责任。
He should take the full responsibility for not perform according to the contract. Excuse me, Your Honor, may the interpreter ask a request to
他
repeat
因为这个
not catch everything.
对不对？
法官
Yes, Ms. Quinn, you may.
OK， 法官翻译可不可以请何先生再重复一下他刚才说的话？因为翻译没有完全记下来他刚才说的话。是的，秦女士，你可以。
就是说这个
请您重复一下您刚才说的话。
被告是Mr. Baker， 他没有执行这个合同，收了我这个给他合同的这个人，他是承包商，他没有按照合同执行这个合同，现在他又改装了那个不同的产品，还是很 cheap 的，很便宜的产品，在我地下，又是不好的工作。
Mr. He, if you can stop periodically so that Ms. Quinn can translate for us. Thank you.
何先生，请您稍微停一下，经常的停一下，以便秦女士能够为我们翻译。Now, Mr. He, would you please repeat and speak in shorter sentences and also pause? 何先生，能不能请您再重复？然后呢，说的简短一点，要停一下，说几句停一下。
我就是说，这个被告 Mr. Baker 先生 ，Mr. Baker David 先生，他私下改装了那个合同上说的 Goodman 的产品，他自己没有经过我的同意，在收我的钱，他没有经过我的同意改装了那个GMC， 这是违反了合同法。
What I was trying to say was Mr. Baker, the defendant, had privately on his own modified the furnace installed something different, and that was not agreed by me. He had modified and installed a different product, which is GMC. So that means Mr. Baker has already breached the contract.
对
I have a question.
我有一个问题，
What evidence did you submit to the trial court to show that he installed a different furnace?
你给原审法院出示了什么样的证据来显示他安装了不同的炉子呢？
他这个是贝克先生给我签的合同，原来的合同 ，The Goodman 写的很清楚的。
This is the contract that Mr. Baker had signed originally. It stated clearly it should be a Goodman furnace.
对，啊，2年的服务，他装好了有2年的服务。
Also 2 years of service. After the installment, 2 years of service.
这是原来的我们2个签好的1900块钱的那个费，我付他现金1900块钱。
This is what we had originally signed the agreement. The fee was $1,900 that I should pay in cash.
Mr. He, I have another question.
何先生，我有另外一个问题。
请讲。
Besides the contract, what other evidence did you show the trial court to show that he installed the wrong furnace?
那么除了这个合同以外，你还给原审法院显示了什么样的证据来表示他安装了错误的炉子呢？
他自己也承认是不同的那个炉子啊，是 GMC 啊，他在法院也承认了，不是这个。
He also admitted in the trial court that he installed the different furnace. He installed the GMC.
Was there evidence that the GMC furnace was not as good as the Goodman furnace?
那么有证据显示 GMC 炉子不像 Goodman furnace 一样的好吗？
当然，我要问那个贝克先生了，那个 Mr. Baker David， 我说你装好了，我说你为什么做这个？他说这个 cheaper， 我要省钱。他说。
Of course, I asked Mr. David, why did you install this one? And he said, this one is cheaper because I want to save some money.
后来他说对不起，我下次不干了。他到这，我说这个不能，你要遵守你这个合同啊，你不能这样做了。后来我就不请他做了。
Later he said, I will not do it again. But I said, you cannot do this because you have to follow
follow contract.
According to the contract. So I will not hire him again.
Mr. He, did you show the trial court any photographs of the furnace that he installed?
对，我有2个 contract 给我。
Excuse me, Your Honor. May the interpreter respectfully request Your Honor to repeat?
这个 contract 是那个。
Mr. He, stop a minute and let the translator translate. Thank you.
何先生，稍微等一下，让翻译进行翻译。Excuse me, Your Honor. May the interpreter request your respectfully request Your Honor repeat her question?
Certainly.
法官可
Did you show the trial court any photographs of the furnace that was installed?
是我
那么
有。
你给原审法庭有没有显示任何照片？就是
有。
给这个已经翻译的炉子。Yes, I have.
第一个照片是这样，原来是 Goodman 是这样的。
The first photograph is like this. The Goodman is like this.
要装这个 Goodman 的。
I wanted to install this
他
Goodman.
装的是这个，
He installed is this one.
是不一样的，很便宜的，是很差的产品。
They're different. It's a cheaper one. It's his product.
后来我请这个公司去看这个 Sigma 那个 heating 那个 cooling 这个去看，他说 exactly 是 good 是不是 Goodman 是 GMC， 你看那个。
Later, I invited this company, Sycamore, to go take a look, and they said it's not a Goodman, it's a cheaper one.
还有另外一家公司，我也给初级法院显示了， 另外公司也去看了，
And there's another company, I also showed it to the trial court. The other
这
company
家公司
also went to
这家公司
the examination.
这家公司叫那个Heating Cooling LLC 那个你们看，
This company is called Heating and Cooling LLC. You can see.
这2家公司都去看了。他说你不是 Goodman， 他说 exactly 是GMC， 这个公司是的 Goodman 很低价的产品。
Excuse me, Your Honor, may the interpreter inquire of Mr. He said.
If you ask him to repeat what he just said, yes.
Yes. 何先生能不能法官翻译可不可以请何先生重复他刚才说的话？
就说
何先
他
生能不能
们这个
重
另外
复刚才说的话
好
？Would you please repeat what you said?
好的，他们那个2家公司去证实查了以后，他说这个不是那个 Goodman 的正宗的产品，是 Goodman 下面那个很差的一个低下的那个低利产品，就是说很次的产品。
The two company had went and checked, and after they checked, they said it was not a Goodman. It was a product that's below Goodman. It's really a bad quality, very bad quality kind of product.
对
You have 2 minutes left, Mr. He.
何
对，
先生，你还剩下有2分钟的时间。
好的，那我就总结一下，就是说反正是他那个要负全部的责任，他要
Okay, then I will conclude that he should take the full responsibility.
他要按照美国的法律，他没有按照合同法执行这个合同。
According to American law, he didn't perform according to the contract.
这是他那个原告，他要负那个美国的法律的责任。
So the defendant should take full responsibility under the American law.
我们都是美国的公民了，现在美国每个人都要遵守法律。你签了合同不执行法律，那你叫什么生意啊？做什么合同？没有承认，没有诚实了。
We're all American citizens. We should all obey the American law. If you are doing business and you sign a contract, then you should honor the contract. If you don't honor the contract and obey the law, then how can you say you're doing business in good faith?
好了，我说完了。
Okay, that's I've concluded what I want to say.
谢谢你们。
Thank you.
Thank you very much, Mr. He. We appreciate your arguments today.
非常感谢何先生，我们今天感谢您进行的争辩。
谢谢。
We will
Thank-
take this case under submission.
我们现在 excuse me, may the interpreter
We will,
inquire.
we will consider this case,
我们将会对这个案件进行考虑，
give you a written opinion.
然后会给您发下书面的意见。
好，谢谢。
Okay, thank you.
Thank
Excuse me,
you.
Honor.
Yes,
Thank you.
ma'am.
Excuse me, Honor. May the interpreter make a correction of her earlier rendition?
Yes.
法官翻译能不能改变一下他早前进行的一次翻译？This was quite earlier during the oral argument, when Mr. Baker was saying that when Mr. He was saying the defendant had installed a different furnace. At the time, Mr. He also mentioned the product installed was an inferior one, and the quality was not as good. The interpreter had failed to interpret that part, and now it just come back to her memory. So the interpreter wished to correct her rendition and apologize for the mistake. 翻译现在想起来，在口头争辩开始挺早刚开始的时候，何先生提到被告安装了不同的炉子的时候，他是安装了质量非常不好的一个炉子，但是翻译当时没有记住，所以翻译现在想起来进行改正，并且为此对他的翻译的错误表示道歉。
好，谢谢。
Thank you, Your Honor. 谢
Thank
谢法
you.
官。
And we will give you a written opinion.
然后我们会给您发下书面的意见。
好，谢谢，Thank you。
Okay, thank you. Thank you.
The next case this morning is Cowan versus Ohio Department of Job and Family Services. Mr. He, Ms. Gwynn, we will ask that you leave us now. If you'd like to watch further cases, you may do so on our YouTube, which is streaming live. And we have the next case, it looks like. Both counsel.
请你
are-
是你们两个位现在可以离开我们的Zoom 直播了，Zoom 庭审了。如果你愿意看接下来的案件的话，那么你可以在油管上观看。Thank you, Honor.
Thank you. All right, our next case, Ms. Baumann, I see you there on behalf of appellant, and Ms. Thomas on behalf of appellee. Are you both ready to proceed this morning?
Yes, Your Honor.
All right, Ms. Baumann, you will have 15 minutes. Would you like to reserve any of that time for rebuttal?
2 minutes, please.
All right, and whenever you're ready, you may begin.
Thank you. Good morning, Your Honors. May it please the court. My name is Amy Bachman and I represent the appellant Mary Cowan. This appeal is before the court this morning because Mary Cowan was denied long-term care Medicaid due to an alleged resource which had no countable value. The primary issues before the court this morning are whether the lower court erred when it determined that the appellant had no standing to bring this appeal, and further, after making that determination, whether the lower court erred when it upheld the administrative decision denying Ms. Cowan's long-term care Medicaid application, because Ms. Cowan does not own available resources that are over the eligibility limit. Regarding standing, Ms. Cowan submits that she is mentally competent. She signed a document allowing her authorized representative to hire legal counsel on her behalf, and she waived any conflict between her interests and the interests of the authorized representative in doing so. She has advanced this appeal in her own name with counsel that was obtained for her. Therefore, standing is not an issue in this case, and the trial court improperly determined below that there was no proper standing to advance this appeal.
And in the trial court proceeding, was she also proceeding in her own name?
She was, Your Honor. Yes, there is no record of this appeal in writing being advanced via anyone but Mary Cowan herself.
Was this argued below though? Because I know this came up and it seemed like the entire, I mean, even your initial brief was completely about this authorized representative issue. And not until your reply brief did you argue, well, it was brought in her name. And I just felt like this wasn't even really argued below to the trial court.
Well, it was mentioned in the second hearing. There were two hearings. There was a hearing before the magistrate on September 17th after the subsequent briefing. And I can actually speak to that a little bit. First of all, Ms. Thomas and I were not counsel of record at that time. We were not present at the hearing, so I can only speak to what I've read and not to what happened firsthand. But to address the issue of standing, it first arose at a hearing in July of 2019 before the magistrate. My former colleague, Nicholas Kulik, at that time identified himself as counsel for Indian Spring. He only told half the story for reasons that I personally don't know. At that time, he also represented Ms. Cowan directly by way of the designated authorized form that was signed by Ms. Cowan herself before the application was even filed. That is part of the record at TD7, page 46, Bates stamp, page 44. In no part of the record or in any brief does it ever indicate that this appeal was advanced through Ms. Cowan's authorized representative, Indian Spring. In fact, the notice of appeal to the trial court that was filed on March 27, 2019 clearly states that notice is hereby given that Mary Cowan, plaintiff appellant, by and through her undersigned counsel, hereby appeals to the Hamilton County Court of Common Pleas. I don't know why the other half of the story was not told. I wasn't there. But what I can tell you is my review of the record shows that we only need to look at the language of the document that Ms. Cowan signed and that the documents that were filed themselves to know that standing exists here. And in that document, she stated, I authorize Kayla Cox, Anna Smythe at the following facility, Indian Spring of Oakley, to be my authorized representative. I also authorize any employees or agents of the facility, including attorneys hired by the facility, to now represent me when, and then some of the things are taking action as necessary to establish my eligibility for Medicaid, taking all actions as necessary to obtain payment arising from and relating to Medicaid eligibility and Medicaid claims. It goes on to say, I understand and agree that all legal proceedings in both state and federal courts arising out of my Medicaid eligibility and/or my Medicaid benefits may be pursued in either my name or in the name of the facility. I waive any potential or actual conflicts of interest which may exist from this appointment. So the intent on the face of that document is clear. Ms. Cowan gave her express written permission for Indian Spring to hire counsel to pursue any and all aspects of her Medicaid eligibility, including in either federal or state court. And she waived any potential conflict between herself and the facility in doing so.
Was there an interim step in there? And that is, did she have an agreement directly with your law firm to represent her?
We do have another agreement that's signed. It is not part of the record underneath because it wasn't necessary to produce until we came to court. I do have another document. I have it available. She knows that this appeal has been filed. She has signed an additional conflict waiver, but because it's not part of the case underneath, it wasn't provided. So that's why it's not part of the record in this case.
Thank you.
And to answer Judge Krause, your question about where it was argued, Mr. Kulik did discuss this in the second hearing, in the transcript of the second hearing before the trial court in September, that the authorized representative document existed and it did give permission to represent her directly. So it's our contention that the evidence in this case shows that standing just simply isn't an issue. It was advanced in Mary Cowan's name. She signed a paper at the beginning, way back before the application was even signed, allowing representation, and who hired the representation is irrelevant. We had the permission from her to bring this forward. So we're asking you to overturn on the issue of standing first and foremost. Second, regarding the issue pertaining to Ms. Cowan's resources. This arises from an application for long-term care Medicaid that was filed on September 21st, 2018. All verifications were sent to the agency, which included bank statements, a professional statement of Ms. Cowan's property from a licensed realtor, and a plot information from the county auditor's website. On December 10th, 2018, the agency issued a notice of action denying Ms. Cowan's application and stating, quote, your countable resources exceed the resource limit for this program, Ohio Administrative Code 5160:1-3.
There's no dispute that that's accurate, is it? Is there that the value of the real estate exceeds the threshold?
There is a dispute to that, actually. At the state hearing, again, I was not present at it, but it's my understanding that there was a dispute as to whether or not some of the information was provided. Ms. Cowan's representatives were not permitted to supplement the record on at that hearing, is my understanding from based on reading what happened. And so there is a dispute as to that value. Yes.
That the supplement, what they wanted to supplement with was emails, right? Where
I think it was
evidencing that they couldn't sell the property.
I believe it was a realtor's statement as to what the value was and the fact that it wasn't sellable.
Okay.
I'm not sure if it was an email or if it was a written statement, Your Honor.
Okay, but so this was not permitted in the record.
Correct.
And that's not an assignment of error that you've raised as far as
it's part, no, it is not a specific assignment of error. No, it's just part of the overall argument that the value of her resources is in dispute. And because it's in dispute, that's part of why we're contending that they weren't countable.
Isn't part of your argument is that there wasn't a willing buyer and therefore it couldn't be sold and therefore it wasn't available?
Correct, Your Honor. And that's the other part.
I have a follow-up to that. What if the value, what if this was a mansion in the suburb of Indian Hill had a fair market value of 5.5 million, and you couldn't find a willing buyer. That wouldn't answer the question, would it?
Well, it does answer the question. The problem here is it wasn't a mansion. It was two pieces of uninhabitable property that she had listed, she couldn't sell, and ultimately she gave them away because she couldn't do anything else with them in order to qualify. And so, the issue is.
Well, that was going to be my other question was if you're stuck with property that is of, nominal value, but it is over the threshold, can you just give it away?
You can, generally there's a penalty period that's imposed. I will tell you, again, this happened after this whole thing, but there was not a penalty period that was imposed actually. Her coverage was just opened in October of 2019 without a penalty period. And she ultimately gave the properties away.
But you can't give them like to family members or to, that's the look back period.
You can
right?
give them, you just have a penalty that's imposed generally. But in this instance, for whatever reason, there was not a penalty which was imposed. And that sort of bolsters our argument that the agency ultimately determined they had no value anyway. They denied her for over a year, and they were two properties that you had to have an easement to get back to them. They were on the backside of a lake. They were uninhabited. They were just parcels of land. She couldn't get anybody to buy them. The HOA fees mounted on them. And so therefore it became a problem. And it ultimately, she has a $138,000 bill because of, two nominal pieces of property. So it's a different situation than the mansions because they were uninhabited and useless.
This is where I get a little bit hung up though. And this goes back to the fact that you were not allowed to supplement the record, because I think it's an interesting argument that if you're sitting on property and you have some sort of evidence that it's unsellable as what you're arguing, that's an interesting argument. Where I'm hung up is the fact that that was not allowed in the record. So I feel like all we can look at is the fact that she owns this property, not that she couldn't sell it.
I agree, which is why our primary argument is that she couldn't sell it, because as I indicate in my brief, we have a decision that comes out of Logan County. In Logan County, Judge Bragg found that the only thing that the applicant had in that case was the right to offer to sell the property, not actually the right to sell. And this goes back to basic principles of contract law: offer plus acceptance equals the completion of the contract. In this case, without the person with the acceptance and the money, there was no way to be able to sell this. There was no right to sell it without somebody who was able and willing to buy. And so
I'm sorry I interrupted you, but kind of going back to what you were trying to say about the difference between this and then Judge Meyer's question about the mansion. So you have the mansion, but you don't have a buyer lined up.
Right.
How is that different?
It's different because in this instance, like I said, it's not the same type of property. It's a very low value property. I think the auditor had it valued at $6,000. It was our argument that I think they were $250,000, which again, that was not supplemented in the record. But even at $6,000, these two uninhabited parcels of property that you needed an easement to get back to, there was no one who was going to buy them. They had been on the market and they were not sold. Like I said, she ultimately gave them away. So, a mansion will probably eventually sell. It may sell for way under the value. This instance, though, she couldn't even give them away. When she ultimately gave them away, she had to beg somebody to take them. So it's a different situation in that sense, because there wasn't a house or anything even on the property to make it attractive to anybody. It was just two parcels on the backside of a lake.
And you are at your time, but I think Judge Bergeron has a question before we go to Ms. Thomas.
Thank you, Judge Myers. Just real quick, but what do we do with the fact that there was the former administrative code section that basically accounts for the scenario where you're trying to sell property and you can't, and then that was superseded at some point? So like that seems to capture your situation, but then they got rid of it. So what do we do with that?
It does, Your Honor. And our arguments in the brief about the CMS approval with the state plan amendment go directly to that. If you look at the code section that Ms. Cowan was denied under, 5161-3-05.1B10, it doesn't exist. It's not a real code section. And as an Ohio attorney who primarily practices in Medicaid, I've gone back and forth with the state on this for a couple of years, and they continue to deny applicants for this reason. It's our contention that this state plan amendment, and again, the arguments are in my brief, but these regulations were never approved. And so yes, the regulation did change, and it did take out the regulation that would favor this particular place where she could have it listed and it could be excluded for the time period that it was listed. But unfortunately, without the state plan amendment and having this properly approved by CMS, it's our argument that these regulations aren't even applicable here.
I'm sorry. So one last question. Which regulations are you saying don't exist and why?
The regulation that she was originally denied under, if you look at the notice of action, and I apologize, I don't have a cite to it in the record offhand, but the original notice of action denying her stated your countable resources exceed the resource limit for this program. Ohio Administrative Code 5161:1-3-05.1 subsection B10. That section actually stops at B9. B10 does not exist. It's just not there. If someone were to go look it up, it's not there. And it was cited as the reason for denying her. And so that's why we made the arguments about the state plan amendment. This couldn't have been approved because somebody didn't catch this mistake. And we've been bringing it to the state for at least 2 or 3 years now, and it continues to be a mistake.
You are at your time if you'd like to reserve 2.
Thank you. Yes.
Ms. Thomas, you have 15 minutes.
Thank you, Your Honor. I don't think we have briefing on the subject of the old regulation versus the new regulation. So I think any argument about that in particular is waived.
So you may be right about that, but to satisfy my curiosity, do you agree that B10 does not exist?
I'm sorry, I haven't had a chance to look that up while I've been sitting here. I wanted to pay attention to the argument. The rule numbering does change occasionally. Every couple of years, a rule might change and the numbering sometimes changes, but the reason stated in the notice, which is different from whether there's a mistake in the citation, the reason stated in the notice is you exceed the resources. That is not a mystery. The resource limit was $2,000. Her appraised property was for $6,000. There was enough notice there. There was a request for a hearing. The hearing went forward. Everyone knew what their positions were. There was a lawyer there. I mean, there's not any trouble here. That's really a due process type argument. And there's no indication that anyone came to the hearing unprepared to make their case, at least based on the notice.
So what would you say if there is a person in the situation as Ms. Cowan, where they've got, land that is essentially worthless, but it is appraised at a value above $2,000. Like they're doing everything they can to sell it. They've got a realtor. They're putting it on the internet, and no one's buying it because it's essentially worthless. I mean, what are you supposed to do then?
So if in that hypothetical, the person would bring evidence to the hearing to show that, to rebut the appraised value by the auditor, and that's possible, and that's done, and people succeed in doing that. No evidence was brought to the hearing on this.
There was only, right?
I'm sorry?
They tried to supplement the record.
No, they did not try at the hearing to my knowledge. And I don't believe there's any indication that there was a request to hold the record open for submission of evidence later, and that was denied. What I believe happened, and I think this is in the record, is in the administrative appeal decision, which is the director level appeal at the agency. There was a comment about how there's this new piece of evidence that's being attempted to be put in at the appeal level. You don't do that. There's a whole process for that. It's under 5101.6-6-02 that allows the hearing officer to hold the record open. And then there's a rebuttal option for the other side once that evidence comes in. You don't just let one side put in new evidence and have, we don't participate in that appeal, by the way. We're not allowed. It's just for the appellant. You don't go to the hearing, bring no evidence, and then on appeal, when you're the only side arguing, put in unauthenticated, unargued, cross-examined evidence and say that, and by the way, that letter by the realtor is in the record because it was submitted. It just wasn't considered proper evidence. It doesn't even have a number on it. There's no value on that. It just says it's hard to sell these properties. We have a citation in our brief of some indication that the properties were on sale for $9,000, even though the appraisal was for $6,000. Perhaps that's a reason why they weren't bought. But anyway, back to your question, if I've answered your question, Judge Krause. Judge Burren, a person can give away the property, which apparently happened here eventually. And for this level of value, at the most, it might have been a 1-month penalty, $6,000. That's about somewhere around there is the cost of a month's worth of nursing home if you're a private pay. So it would have been a very short time, if at all. And as Ms. Bachman indicated, apparently by the time that this happened, maybe there was an indication that satisfied the agency that the value is under the resource limit. But at the hearing, the only evidence offered was $6,000. And the hearing officer can't do anything else but trust the auditor, the appraiser, if that's all the evidence that was brought in. There's just no other way to do it. There's no, can't guess, you can't take people's word for it with no evidence. But
if they had, I mean, could they have gotten the realtor to say that it's my experience based on my knowledge of the real estate market that this value is $500 or nominal, or do they have to have like a formal expert to do that?
So I don't think there's a whole lot of formality at these hearings. I've read of cases where people brought in a letter from a realtor, or maybe a realtor comes as a witness, but I've seen cases where people have rebutted the value of something with some evidence that they have. And the hearing officer will say, you know what, or maybe on appeal later, actually you did successfully rebut that value. But when there's nothing, there can't be a different outcome. There wasn't even an attempt. Maybe they could come to this court or to the lower court and say, look, we think we brought good evidence and they didn't think it was good enough, but there's nothing. When there's nothing, it can only go one way, and that is with the auditor's appraisal. What auditor by law is charged to determine the fair market value of property. And that's all that there was. The agency wasn't trying to deny somebody benefits who qualified. It's just that what we had was evidence that she had resources worth more than the resource limit. And the rules say that, and the federal rules say, we have to deny someone benefits if they have too many countable resources.
Can you address the standing question, particularly the fact that this was brought, unlike some of the other cases that were cited in the briefs, this was brought purely in Ms. Cowan's name?
So the document says Ms. Cowan name on it, on the notice of appeal, but the lawyer below, who we should presume knew who his client was and knew who took the appeal because he's the one who did the work, he said multiple times that he represented the nursing home. He conceded multiple times that the nursing home took the appeal. He said it, for example, in open court, pages 52 and 53, he defended the nursing home's right to take the appeal under the Tiggs case. In the supplemental brief that he filed, pages 4, 6, 8, and 10 are examples of concessions that the nursing home took the appeal. In the objections to the magistrate's decision, there's concessions that the nursing home took the appeal. And even in, as Judge Krause pointed out, in the initial brief in this court, there are at least 3 times where it's obvious that the position is that the nursing home.
They're arguing that the nursing home could take the appeal, but as I read the notice of appeal, the filing in the trial court and the filing in front of us, it simply lists one appellant, Ms. Cowan, and then counsel says attorney for appellant. So like, why would we look beyond that?
Because the lawyer said it himself several times and lots of times. He said the nursing home took the appeal. Tiggs allowed the nursing home to take the appeal. Ms. Cowan signed a form that allowed the authorized representative to hire a lawyer to take the appeal. It goes on to say, and by the way, even though there may be a document that authorized the lawyer hired by the nursing home to represent her, Ms. Cowan, that doesn't mean it actually happened, right? Doesn't mean that he actually had a client relationship with her. And it's important to know
they've represented to the court that they are counsel for Ms. Cowan?
Well, the magistrate said that Mr. Kulik admitted in open court that he represented not Ms. Cowan and only the nursing home. The magistrate found that as a fact. That was what Mr. Kulik said. And there was no objection to that in the objections to the magistrate's decision. And Civil Rule 53 says, I mean, if nothing else here, if we don't have regular waiver, we have a prohibition found in Civil Rule 53 that says if you don't object to a factual finding by the magistrate, you shall not assign it as error on appeal. And again, as Judge Krause pointed out earlier, this was not argued until the reply brief in the Court of Appeals after we were all done arguing. I mean, we've been arguing about the Nursing Homes Authority for a long time and in many, many different documents, briefs.
That's why I'm so confused, because I just feel like this authorized representative issue was such a, I mean, it seems like a very simple, if the lawyer represents Ms. Cohen, we're done. Right.
All of that was unnecessary. And
I'm just kind of perplexed how we're here now with such a simple standing issue.
All of the discussion about how TIGS meant that there was standing below is a concession that the nursing home took the appeal. What else could it be? It can't be anything else. And you don't need two people to take an appeal. In fact, you're not even allowed. So it's just been said so many times that the nursing home took the appeal. I don't know how it can change now on appeal. And it's a fact. It's not even just a legal argument about jurisdiction. This is a fact supporting a jurisdictional conclusion. And the reply brief at the Court of Appeals level is just too late to try to enter into new fact based on counsel's speculation. We have the original counsel's own words saying that he represented the nursing home and that the nursing home took the appeal.
But if we go with the authorized representative argument, can you just briefly, because I'm having a hard time understanding how an authorized representative can represent somebody through the agency level and then they just get stopped on an appeal when we're just dealing with benefits here. And why can't they continue on?
So I would say it a different way. There's an agency rule that allows people to have special help at the agency level. That's all the power an agency has anyways, to create rules that are about its own proceedings. Agencies don't have the power to make rules about who has standing in court under a statute. That's just not within the agency's purview. The Brea Court, the Seventh Circuit decision, the only circuit court that I'm aware of to have addressed this issue, overruled the case that TIGS followed, by the way. So the case that TIGS relied on is no longer good law. That's the Norwood case. Seventh Circuit, I think, does a very nice analysis of this. But even in Ohio, let me start with Ohio law. In Ohio law, 5101.35 is the statute that authorized this appeal, and it defines appellant. And the authorized rep, the nursing home doesn't even arguably fit under that definition. It has to be an appellant, someone who is a former or current participant or recipient of a program benefits. And of course, then we have other statutes and common law traditions that allow certain people to represent an individual in court. Lawyers, guardians. I mean, the guardian would have to hire a lawyer or be a lawyer, but we have other people who can take on these representative capacities. And the Harrison case points out that if you're not a party to a proceeding and the statute doesn't say otherwise, you can't take an appeal.
But doesn't the authorized rep just stand in the shoes of the person?
At the agency level, yes. The rule that authorizes authorized representatives applies only at the agency level. It has nothing to do with what happens in court. It can't have anything to do with that. Agencies don't have that power. And as the Brea Court pointed out, those words in the rule that the appellant is relying on, they are part of a list of very narrow tasks that would all be meaningless if the rule said what the appellant says, if they say that it says. And it says you can sign an application, you can submit a renewal form, you can receive communications and notices from the agency, and then act on behalf of the appellant in all other matters with the agency. It doesn't say litigation against the agency. And the Brea Court pointed out that if you read those in pari materia together, the most natural reading is that that's just other things that happen with the agency at the agency level. The introductory statement in the authorized representative rule says what the agency has to accept. And it's all about what happens at the agency. And Brea says you match that with the task list. The agency has to accept these things. the authorized representative can do these things that the agency has to accept. They should mirror each other. That makes sense. The rulemaking comments that the federal agency.
Let me ask you
made-
this, under
Yes.
under the statute where it defines appellant to include an applicant. What you're saying makes sense when you talk about going from agency to court, but that statute also applies for agency appeals. And if we agree with your reading, then that would say the authorized representative can't partake of those.
So the
Because
agency.
that would mean that appellant can never include the authorized representative.
Understood. So I need to separate what happens at the agency versus what happens at the court. So at the agency level, the agency can say who can stand in the shoes of an appellant. It has the power to do that. And so it can interpret rules in a statute for its own purposes. And it has done that and also federal law requires that. And the federal rule is what we're talking about here. Ohio does what the federal rule says we have to do. It allows the authorized representative to help someone at the agency level. And so there's a reason why you can say that a person who stands in the shoes of the appellant, they're authorized to be to help the appellant in that situation. But when you get to court, the agency's rules don't have any bearing on what happens in court. And I want to mention that the person who's thinking about appealing to court is in the same position every single other litigant is in the world. There's not a due process problem like the Teagues Court oddly stated. This is that you're in the same position you are and everyone else is in. You can represent yourself. You can hire a lawyer. If you have a guardian, your guardian can hire a lawyer and be in court for you. It's not something that you're deprived of when you get to court. You just get this extra benefit at the agency level because that's what the federal law decided should happen at the agency level. And every indication in the rule and in the purpose provision for that set of rules and in the beginning of the rule and in the comments that the federal agency made, all of that points to the agency level only as the Seventh Circuit recognized.
So once you get to common pleas court, you got to hire a lawyer. Is what you're
Or
saying.
represent yourself, or your guardian can do it, or your maybe power of attorney, or if you've,
But the authorized rep can't do it.
they don't have a legal status that is recognized in court. I can't tell my neighbor to go file something for me because it's a neighbor status representation. I mean, we don't just add extra things to court standing, and the statutes and common law govern who can represent someone in court. Agency
Ms.
rules do not, yes.
No,
Sorry.
I'm sorry. You are at your time, but I do have one follow-up question for you, if I may, and that is, assuming all of that is true, I go back to the very beginning, and maybe one of the first questions Judge Bergeron asked you. We look at the docket and the notice of appeal, the filing in the common pleas court, and at least it purports to be brought in the name of Ms. Cowan. And despite the fact that the attorney said, no, I'm representing CareSpring, the action is brought in her name. What do we do with that?
I would normally say you presume that what that document says is true, except that we have the actual lawyer saying it's not true multiple times.
Was he
Multiple
saying, I represent CareSpring? Did he ever say, I don't represent her? Because he clearly represents, in the general sense, he has two clients, the nursing home and Ms. Cowan. And the person who has the interest in winning this is perhaps more CareSpring than Ms. Cowan, because that's who's going to be unpaid at the end of the day. I mean, did he ever say, I'm not representing her?
So I don't know if I can point to a specific sentence that says I'm not representing her, but when the magistrate said that he was not representing her, and he did not object to that, nobody objected to that factual finding, and it's not supposed to be challengeable on appeal. If there's, I mean, that would have been the time to say, whoa, wait a minute, I didn't say I didn't represent her. He didn't. He just kept saying, I represent the nursing home. The nursing home had the right to take the appeal, and the nursing home did take the appeal, and that was fine, and therefore they were standing. See Teagues. over and over and
Well,
over again.
but I would say maybe the nursing home didn't take the appeal because it's not in the name of the nursing home. I mean, maybe he's just wrong about that, but you've answered my question, and I don't want to extend beyond the time. Do any of my colleagues have any follow-up questions on that or other issues?
No.
All right. Ms. Baumann, you have 2 minutes remaining.
Thank you, Your Honor. I did just want to point out that in the second hearing, on pages 59 and 60 in the September hearing, 2019 hearing before the magistrate, Mr. Kulik did argue what was on the actual document, the contents of it, and what she signed. So I believe the argument was in there, and Judge Myers, you're correct. He never indicated that he didn't represent Ms. Cowan. He did indicate that he represented CareSpring. He did represent both, is the bottom line fact of the matter. And we have a document in the record which shows that. To go back and very briefly address the issues earlier regarding what was said at the hearing and what was brought and what wasn't. Despite providing the statement as part of the verifications from the realtor, and despite testimony that was given at this state hearing from Ms. Cowan's authorized representative about what was included in the verifications, there was a conflict as to whether it was there. The caseworker said she, sorry, I accidentally muted myself. The caseworker said she didn't have it. Ms. Cowan's authorized representative said she submitted it. They were not permitted to give any additional information. Mr. Kulik did submit an administrative appeal. He did submit it and state at that time, I wasn't allowed to give this sooner. Again, I was not there, so I don't know, specifically what happened, but there was a conflict back at that state hearing. There is a record of that conflict back at the state hearing about what was submitted and what was not. And going back to the very bottom line issue about availability, as I said, ultimately she had to give these properties away. They were always without value from the very beginning. There was nothing about them that changed between the time when she submitted the initial application and the time when she ultimately gave them away over a year later. They were given away in March of 2020, or excuse me, April of 2020. She was given benefits in March of 2020, dating back to October 2019. And again, there was no penalty period that was assessed for giving those away. So at some point, ultimately, someone else decided that these didn't have any value, and they didn't. And that's the bottom line issue.
So is this moot, or are you saying that you still want to recover for a period of time when she was denied benefits?
No, Your Honor, it's not moot. We do want to recover for the period of time that's missing, and that's September 2018 to September 2019, plus the 3 months of retro benefits, which would apply under this for June, July, and August of 2018.
Okay.
And
So we're asking for a remand for that.
all right, you are at your time. Does the panel have any other questions? All right, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you, Your Honors. Have a
Thank
good
you
day.
both. Our next case, and I will wait and allow the parties to enter the courtroom. All right, I think everybody is in the courtroom. Our next case is Dula versus the City of Cincinnati. Actually, I see Mr. Boat just coming in. And I believe that there are only two parties arguing today, I believe. Hold on a minute. No, I'm incorrect on that. Mr. Dula, you will go first, and we have granted you an additional 5 minutes. So you will have a total of 20 minutes to argue. And then I guess we can just take this in the order filed. Counsel, have the defendants discussed how they would like to divide their time? I'm sorry, the appellees, have you discussed how you would like to divide your time?
Judge John Vogt on behalf of the city. We did talk earlier today. I think our side still has just 15 minutes. That's correct?
Yes.
So whatever that is, I think we'll at the most need whatever that is divided by 4. So 3 minutes and 45 seconds per appellee. Should be more than sufficient.
All right. I won't be able to keep the seconds, so I'm going to let you all keep an eye on that. If you want me to try and keep approximately 3 minutes, I can do that, but it might be easier if you all keep track and just decide who's going when. So,
3 minutes per 3 minutes per appellee sounds good, Your Honor.
all right. Mr. Dula, you also have the ability to save some time in your argument after you hear from the appellees. Would you like to reserve any of your 20 minutes for that rebuttal?
I want to reserve 3 minutes for each appellate.
Okay. So let me I want to make sure I do my math correctly here.
And I'm sorry, Judge Myers, but
12 minutes.
do we have 3 appellees or 4 appellees?
I think we have 4, but I
Oh,
only see
then-
3.
Then I would like to reserve 2 minutes for each.
All right, 8 minutes total.
Yes.
All right. So what we'll do, Mr. Dula, when you get to your 8 minutes, I'm going to let you just use that 8 minutes however you would like to after you hear their arguments. So that will leave you at the beginning with 12 minutes to argue the first part of your case. And whenever you're ready, you may proceed.
I would like to explain my condition first.
All right.
I had a stroke and I have aphasia. And what that means is that I can't find words and I forget words that are significant. And I'll say things that I don't mean. And my ex-wife is back here behind me to give me the words that I'm speaking. But as you can see, that's how I talk.
Sir, we will be very patient and accommodate you as need be. As I said, we are giving you an extra 5 minutes. So I will start and keep track of your time. Whenever you're ready to start, you will have 12 minutes at the first part of your argument.
Okay, I'm ready.
Okay, then whenever you're ready, go ahead and start.
Okay, well, I want to say, first of all, that I didn't want to represent myself. The last person that I spoke to, a prominent attorney, told me that I couldn't prove Mark Magner could read an MRI. Now, Mark Magner has to have, Mark Magner can't be a neurosurgeon and read an MRI. And it's just a preponderance of the evidence that I have to prove. That is what I've been up against with the city. And I have to, when you review my briefs, and I watch, of course, YouTube, your YouTube things all night. And when you review my brief, you should have been horrified. Matthew Schuler, well, let me explain my condition first. Right now, I have to have a surgery. They have to cut again my back. They have to pull out all the equipment and sew me up and then go in through the front and do the same thing that Mark Magner didn't do.
Well, so then, sir, your underlying issue is malpractice, is it not? Medical malpractice?
No, it's because he did it intentionally. And I can prove that he did it intentionally because he did a second surgery on me. He knew I had what he called a foot drop. But what I found out later, and I had to investigate that, he intentionally put something on my spinal cord and during the first surgery in 15. That's what he said was a foot drop. He continued to see me as a patient and didn't tell me what he did. He placed something on the nerve, and I reviewed that because of the MRI statements that were made. He knew. And then he sold me up and let me go. And when I came back, I went and had I went to the emergency room because I was just in so much pain. And I went and they did an MRI, and they said that I had something on my spine. He went and he said that, he just his cage dropped and he had to, go ahead and do it again. Now, this is significant because he did the surgery again. And, my foot was, it went back. But I have nerve damage. I don't have any feeling in the back of my leg, and it's going to come together. And my foot has been asleep for the entire 4 years, and that's going to go on. I know about the medical malpractice. He did it, and it's no doubt that he did it. I have to have surgery again. I told you. I went to all the documents. Matthew Schuler did a document dump on me. I went through all the documents. Now, what they didn't anticipate is that I used to work in the medical field, in billing and in claims. I knew what he had done, what to look for. And I looked, and he said, now he did the second surgery. He said he told me that he wouldn't have to, and you know, because I have the link that you could listen to. He told me that he only had to replace my rods. He, in the report, he said that he opened me up and he literally pulled the screw out of my L5S1. Now, the thing about it is, okay, now he sewn me up, but he never completed the surgery. It's a requirement that a jacket is given. It's a requirement that a jacket is given. And he didn't do it in the first surgery, and he didn't do it in the second surgery. And he knew I wouldn't be fused. He knew. And he set me out without a jacket. Now, I will get to Mr. Gibson. Now, basically, Mr. Gibson took my information. He looked me up. Casey looked me up on LinkedIn. I got all the emails. I got everything. He looked me up on LinkedIn, and he came to me And, you know, I went and met with him in his office, and he went to where Matt or Martin Magner was. He said, okay, he took all my files, took everything. He did that for 2 weeks. 2 weeks. Now, he came back to me and said he couldn't take my case because the nurse said that there was nothing he did wrong. Now, if I was not fused, and it's a haloing which they see in the images and the x-rays. Now, if he only said he wouldn't take my case after I pressed him because the medical board wanted my information, and Casey said, and it's all in the email. Casey said
Mr. Jewell, wait a minute, please. Mr. Kunkel, I think your microphone might be on.
Yes,
Thank you. I
lost my train of thought. Yeah, Casey said, it doesn't make any difference. If Bradley Gibson, if the nurse would have looked at the images, she would have seen haloing, and I was not fused. I'm still not fused. He lied. He lied. And make it be clear, when I went to his office, he tried to make me stay in his office. But you know what? I went and looked at him. He said he had an emergency meeting and he had to go. But I went and looked at him talking on the phone and took a picture of him like I always do. Took a picture of him on his phone, and I know he was talking to Matthew Schuler. I know, and we gonna get to Matthew Schuler. Matthew Schuler said that, and it's in an email that, and it's in evidence, that he said that the term he looked into my case and what Martin Magner did. And he said that they didn't find anything wrong. And he was, you know, when he keeps, if I kept my appointment with him, that he would not talk to me about that. But I terminated my relationship with him in 17 when I was supposed to make that appointment. Again, I am not fused. Again, I am not fused. And
Mr. Dula, you have about 2 minutes left on this first part of your argument.
Okay. Now, the city, I do have a right. I have a right to due process. And due process is, if I file a complaint, the officer would have to look into it. If I file a complaint, if you don't have to prosecute, but you do have to look into it. The prosecutor's office and the police told me, and it's in the video that's entered into evidence. The police told me that I had to have the first interaction that I had to have of the state medical board bring charges on my behalf. But I knew that it was a lie because I had talked to the state medical board. So they refused. They refused to do anything. The second interaction with the officer in District 1, again recorded and entered into evidence. She said that she didn't feel comfortable. She didn't feel comfortable. And that was it. She took my report. But when she took my report and I referenced the number, because you gotta get a reference number. Nothing. She didn't place Mark Magnus' name, nothing. It's just, I filed a complaint. You know, that is not fair. That is not due process. And I did look up the statute of repose, and I have 4 years to file a lawsuit from the time that I found out that I was not fused.
Mr. Dula, you are at your time. If you would like to save your 8 minutes.
Yes.
All right, thank you. Mr. Vogt, I did neglect to ask if the appellees had discussed what order they intended to argue. We can do it by the filing of the brief if that's easier, or if you all have already discussed it, I'm willing to do that as well.
Judge, we did not discuss the order, so really whatever is most convenient for the court. I
Well,
think.
then in fairness, I'll do it in the order of the briefs that are filed. Let me just tell you what that is, and then I will keep the 3 minutes, and who's ever at the end, I suppose, can use the additional time. But the order of filing would be first the Finney Law Firm Group, second would be the county commissioners, third would be Christ Hospital and Dr. Magner, and last would be the city of Cincinnati, again, in terms of brief filing. So, Mr. Gibson, we'll start with you. I'll try my best to keep let you know when 3 minutes are up, and then we can go to the next party.
Okay, thank you, Your Honor. From the standpoint of the Finney Law Firm and individually named was myself and my colleague Casey Taylor. The only allegations in Mr. Dula's complaint against us is that he asked us to review a potential medical malpractice case, and that within 2 weeks of that initial meeting, we notified him in writing that we weren't going to pursue the case and advised him to look for another attorney. And that is it. So, you know, we moved to dismiss under the theory that Mr. Dula's claim for fiduciary breach was an attorney malpractice claim. That statute of limitations is 1 year on that claim, and by the time Mr. Dula filed his complaint, it had been over 2 years since we had met with him. So we have a fairly straightforward argument. I would just submit on the briefing and that, and ask the court if there are any other questions they would like me to answer.
No, and you only used about, it looks like 2 minutes, so I will try and keep track of that as well. Next, then, let's have counsel for the county commissioners, Mr. Kunkel.
Yes, thank you, Honor. The court, your public prosecutors represent the Board of County Commissioners.
Counsel, Mr. Kunkel, we are really not breaking up terribly. I'm going to ask you to put yourself on mute, and we'll go to the next party. All right, let's skip over Mr. Kunkel for the time being, and we will go then to Mr. Hines on behalf of the hospital and the medical defendants.
Thank you, Your Honor. On behalf of the hospital defendants, really, it's pretty clear from the record in this case, I believe, that there is no medical claim actionable presented by Mr. Dula. In addition, as several courts have pointed out, he has no constitutionally protected right or interest in the prosecution of the physicians who have cared for him if he's not intending to prosecute that himself. The operative dates here, as Mr. Dula alluded to, he had a surgery in September of 2015, a second surgery in October of 2016, and in early 2017, he contacted the hospital, threatened litigation, and made a demand to be paid, which was investigated by the hospital. And in February 2017, they declined to indulge that request. Mr. Dula then filed his first lawsuit in federal court, which did not include any claims against the hospital defendants. He then refiled twice in common pleas court. And there have been 3 judges who have reviewed this case on its merits, found that it had no merit and dismissed it with prejudice. There's also been a federal magistrate who did the same. For those reasons, we believe that Mr. Dula is not entitled to any recovery against the hospital defendants. And we would therefore ask the court to affirm the lower court's decision in this case, which we believe is not only barred on the substantive law applicable to the nature of his claims, but also given the doctrine of res judicata.
All right, thank you. Mr. Vogt, let's hear from you next. I'll keep track of 3 minutes, but I will say that the people before you have not used their allotted time if you'd like to use a little more.
Thank you, Your Honors, and there's the court. Respectfully to Mr. Dula, I don't think I heard any issues really raised today that weren't adequately already covered in the city's briefs, so we would just simply reiterate our position with regard to res judicata. This is the 3rd case involving Mr. Dula and the same litigants. And again, for the reasons stated in the briefs, the city is afforded qualified immunity both under state torts, and because Mr. Dula doesn't have a right to prosecution of another, his claims under federal due process are barred as well. So the trial court got it right. If there's any questions from the court, we would just submit.
All right, thank you. Mr. Kunkel, I'm going to come back to you to see if we've worked out the technical issues with your staff.
Your Honor, I hope you can hear me now. We would just submit on the briefs unless there are any questions.
Does this panel have any questions? For Mr. Kunkel? Right, thank you, Mr. Kunkel.
Thank you,
And I
Judge.
will ask you to put your mute button on again because we have an echo.
Yes, ma'am.
Mr. Dula, you have 8 minutes remaining.
I am not a lawyer. And they beat me up with a whole lot of document dumps, and all this res judicata and all that. They have not spoken to. I'm dependent upon you as judges to look at my briefs, look at the briefs, and look at the links in the briefs. They speak for themselves. The Natalia Harris, and he didn't bring up Natalia, and I wouldn't either. Natalia Harris was the one who sought me, and she called me and told me that I could file my charge myself. Now, it wasn't the case. It wasn't the case. I couldn't file a charge. Hamilton, the city of Cincinnati and the county cannot find where they investigated anything. I mean, and I don't even understand. It's like I'm in the twilight zone. I don't have a right to due process, and they just said that. I just don't understand. They blocked me, and you as judges know it can be done. They blocked me from getting an attorney anywhere. I looked everywhere, but I got here. And I'm not going to stop because they were wrong. Natalia Harris and Brian Gilligan conspired. They conspired. It's in the briefs. they conspire to send me away. The only thing is that I wouldn't go away. All these people got sucked in to this because they just wouldn't give me my rights to due process. They wouldn't even investigate. But Natalia Harris said she investigated. And Natalia Harris, in the evidence, Natalia Harris said she read my MRI. She read my MRI and she didn't see anything wrong. She read my MRI. Prosecutor Natalia Harris, that's in Delaware right now because she ran too. Mark Magner is in Wheaton, Colorado. And I think Judge Krause, I think that's your name. You have posed a question on YouTube, and you posed a question, it pertains to Dr. Durrani being retired or Dr. Durrani being escaping. Mark Magner escaped to Wheaton, Colorado, so that I couldn't continue to pursue him. And if you look at the city of Cincinnati, he's still listed as a Christ Hospital physician. And you said, Judge Krause, that it was a determination as a certification. And he did that. And I just want Ohio Revised Code 230511.113 to apply to me, a state of repose. And I don't fully know what that means, but you know, and I'm not an attorney, but I'm a just private citizen, and y'all are not the judges, but you all as representatives of the hospital city, and you gonna take your knee off my neck, because I'm gonna fight. I'm gonna fight. I'm done.
All right, thank you, Mr. Dula. Counsel, thank you as well for your arguments today. Mr. Dula, we will take your case under submission and we will give you a timely written opinion. Thanks to everybody for your arguments today.
Thank you.
That will conclude this case. And our final case for argument today is the State of Ohio versus Jackson et al.
Maybe.
Looks like everybody is here for the case of State of Ohio versus Jackson. And Ms. Kelly, on behalf of the appellant, and Mr. Sayre on behalf of the appellee. Ms. Kelly, you will have 15 minutes to argue. Would you like to reserve any time for rebuttal today?
I would. I'd like to reserve 5 minutes for rebuttal, please.
All right, I will keep track of your time. Whenever you're ready, you may begin.
Thank you. I appear today on behalf of Allegheny Casualty Company, who is the surety in this matter of Jackson Wayne's bond that was forfeited in Hamilton County. This is actually an easy case preliminarily, and that's very first we have to look at the notices that were afforded under Ohio Revised Code 293736C. And did anybody receive notice within 15 days of whenever the bond was forfeited? As you know, he failed to show. Judge Baradin, during a November 20th hearing in 2019, said to us, well, I gave defense counsel some extra time to produce him, so I waited to forfeit the bond. That was finally done. The bond was forfeited. A warrant in capias was issued on 5/21. Nobody was notified. The statute requires at that point each surety, and in this case, each surety being Daniel Sifu and ACC, because they're separately captioned on the notice to sureties. So they treated them as two separate entities. Nobody was notified. There was no notification until 7/3, and then there was a follow-up notification without any explanation on 7/18. Now, the problem was on 8/20 and 9/6, and unbeknownst to us, the mail came back returned on Daniel Sifu because he had been indicted on some federal charges and was not conducting business properly. So we had to come in and, as you can imagine, cover a number of bond issues and bond forfeitures at that time. But in any event, this is the easy case under that notice because it wasn't done. It is a shall, it's a mandate, and the legislature has heavily statuted these positions on these bonds because it's so important and there's so much money at stake. So
Aren't there cases out there that say if the notice requirement wasn't timely complied with, we need to look to prejudice?
no, not the cases that I cite to, as well as the case that I won in Wayne, in part in Butler County Court of Appeals. The trend of the courts is definitely that that's a precursor, and the mandate under the statute is that they must get the 15 days notice or the surety's been prejudiced. Because what happens? What happens is if either they're in flight or they're doing other crimes, or in this case, incarcerated in another jurisdiction, every surety, everybody who's got a financial stake has to be notified as soon as they fail to appear, because the likelihood of apprehending and getting the defendant.
Well, but I guess that ties into Judge Meyer's question of like, what would you have done? He's sitting in jail across the river.
Well, I mean, and under the law, if he is incarcerated in another state under .40, that's good cause
Well,
to
what
show
if we,
for production of the body is the fact
but
that
if we were to disagree with you on that, then I guess that's kind of my question, and it ties into the prejudice question. Like, what else would you have done as a surety in that circumstance?
Well, I mean, if we had had notice, and it took us a while to figure out, as you can imagine, the very next day after he pled out in Hamilton County, he was arrested in Campbell County, and he's been since convicted. Under the Sexton case, the fact that we can show that there is a police action keeping him from our processing of his case allows us to, if you will, suspend that bond forfeiture until he's available to be processed for that case. He is presently on hold at Campbell County. Once he serves his sentence, and in fact, the case is still active in Hamilton County with Judge Barrett's replacement. I checked the docket last week. So that case is active. We've notified them. He is on hold with Campbell County. So this is not an instance of performance denied. This is an instance of performance delayed. And in that
is he at the Campbell County Jail?
He is in the detention center. We provided that incarceration record. I believe it was updated while it was in the Court of Appeals.
So his Kentucky case is concluded and he's serving his time. There's a KPS here in Hamilton County for him. So
not only KPS, we have a hold on Campbell County for him. So when they're going to release him, we are going to process him. I mean, Campbell County, I guess, is only about 6 or 7 miles away from you guys. We're going to process him over so that his case can be concluded.
So there's not a situation where they would release him back into society and then he would run.
Correct.
Okay.
But let me back up for a minute, because he was arrested in Kentucky, correct?
That's correct.
Which violated the conditions of the bond that he was out on in Hamilton County because he left the state without permission, correct?
That is correct.
Doesn't the first district case law, I know there's some, maybe in other parts of the state, cases have been decided differently, but doesn't our case law say that that's not good cause, that was foreseeable that he could get picked up, and then therefore your client hasn't shown good cause of why he wasn't produced?
Sure. I mean, I think the most classic case that I see is the Lott case. And in that case, at the time that his mother and the sureties put together his bond, he was already on parole in Indiana, and they knew that. And once he committed crimes in Ohio and his parole officer wanted to see him in person, the trial judge did not give him permission to leave the state. And of course, sure enough, he goes over to that neighboring state and he gets nabbed. I think that the standard under all these cases is still foreseeability. And in many of these cases, like Hughes, our longstanding Ohio Supreme Court case, the gentleman was out and had failed to appear on 3 different occasions. There was a long time lapse in not only the commission of the crimes, but in the case Flight, the Sexton case, where he went and lived in another state and then he got incarcerated in a 3rd state. That's cases of foreseeability. Otherwise, a surety, if somebody goes out the very next day and does a crime spree, they can have a very large financial impact when they were not.
I guess that's my question. Why would that not be foreseeable?
I mean, the fact that foreseeability to me is fact driven, and foreseeability is based on the fact of what is the surety's contract? It's for appearance. And the surety, that's why these notices are so important. The surety has to get prompt notices so they can take prompt action. And in this case, be able to go back to the court and prevent the bond forfeiture by saying, yes, he's incarcerated, and under 2937.40, production is excused by good cause if he's incarcerated in some other jurisdiction. And we have cases that hold, whether it's a police action by an Ohio county or a police action by a neighboring state, that is an impossibility of performance. And under various cases, it has been shown to excuse performance and prevent bond forfeiture, which is only fair here.
Well, it seems like your argument is, that's kind of what I'm looking at. It's more of an impossibility argument than a foreseeability argument. And, you know, the point of bail bond or bond is to help secure a defendant's appearance. And it seems like, and this is what you alluded to at the beginning of your argument, that, you know, there is some precedent on just staying or suspending the forfeiture because it's not like the defendant just disappeared. Which is foreseeable, I would think, for a surety. But we know exactly where he is, and there's a holder on him, so he can be produced at some point. So I feel like that's more, you know, your argument, because certainly I think it's always foreseeable that somebody's going to leave the jurisdiction or violate their bond, right?
I mean, foreseeability versus impossibility. Yeah, I think it's always foreseeable, but where the cases differ is how much notice, you know, if the surety undertakes a risk and he's either on probation or has been a flight risk in the past, then you know what, that's to me a lower standard. They're taking a greater chance that he's going to have those behaviors again. But it's also really a fairness type of thing. And that's why that Ohio Revised Code section, I mean, it has been amended a number of times to tweak the timelines and to put into the statute what is impossibility, if you will, of performance. And if he's incarcerated somewhere else, they realize that, you know, even now we have Zoom and it's made it easier, that there's going to be an impossibility of getting that defendant back in there. And are we going to make the surety pay a $50,000 or $100,000 penalty because of that? You would very quickly put bail at real peril if you adopted that type of situation and didn't look at the facts driving it.
So are you asking for, what you wanted in this case was a suspension of the hearing, right?
I mean, really either a suspension of the bond forfeiture itself until he can be brought back to Hamilton for conclusion of his charges, or in this case, I'm saying right off the get-go, there was extreme prejudice by not serving those notices 15 days on anybody. I mean, they served them on Sifu and us 43 days later, and both of Danny Sifu's notices came back returned. So there was not good notice at all in that principal agency kind of argument that would have allowed Sifu to answer for us, because by then, unbeknownst to us, he was indicted and not doing the business that he should have been doing. We came in as soon as we could figure out what was going on, but part of their duties as bail bondsmen are to attend these routine hearings, etc. So the fact that we didn't get notice is completely, to me, a reversal moment, and that it should reverse the bond forfeiture in total. The fact that nobody got notice 15 days under the statute. It is a shall mandate. And to me, you know, that is as good of an argument as the impossibility of performance.
Ms. Kelly, I think you said you wanted to reserve 5 minutes. Am I
I do.
correct?
I
All
do.
right. You are past your time, but
I'm sorry.
you will have 5 minutes because your last answer was prompted by a question. So you will have 5 minutes. Mr. Sayre, whenever you're ready, you've got 15 minutes.
Thank you, Your Honors. I'd like to address the notice issue that Ms. Kelly brought up first. As an initial matter, although Allegheny asserts it didn't receive notice, it did in fact receive notice on July 3rd and on July 18th that there was going to be a show cause hearing on September 4th, 2019 in front of Magistrate Rents. Now, I will concede that that notice went out past the 15 days mandated by the statute, and I don't have any explanation for that. But Allegheny did in fact have notice of that hearing on September 4th, and did not appear. That hearing was uncontested, and that's just the way it was. There are in fact numerous cases in Ohio dealing with the prejudice issue and whether this is a hard rule that the state must always follow, or whether some prejudice is needed on the part of the surety. The case Giant State versus Lott, that held that the shorter time frame was not prejudicial to the surety and therefore did not constitute good cause to set aside the forfeiture. That case cites a case out of the 6th District, out of Sandusky County, Department of Liquor Control versus Calvert, which held that unless the surety can show prejudice, i.e. unless the surety could have demonstrated good cause, then the trial court did not abuse its discretion in entering judgment against the surety when the notice did not go out in the statutory timeframe. So there are in fact cases in Ohio and in this county where it has been held that this statutory timeframe is not a timeframe where if it's missed, it's an automatic remission. There are a lot of cases.
You're not arguing, are you, that it's not a mandatory time? It is mandatory, correct?
Correct, Your Honor. The clerk properly should have sent out notice in 15 days of a hearing, 45 to 60 days from the forfeiture. My point is that courts have held that it was not an abuse of the trial court's discretion to allow that forfeiture if that rule is, if that time frame is missed, as long as there's no prejudice to the surety. And in this case, the surety can't demonstrate prejudice. They didn't show up at the September 4th hearing to contest the forfeiture. And the defendant was already locked up in another state. There was nothing they could have done to produce the defendant in court that day. Moving on to the impossibility defense. An essential element of the defense of impossibility of performance under a contract, which this bond was, it requires there to be a showing that the incident that led to the impossibility of performance was unforeseeable. The cases in Ohio are very clear that the risk that the defendant will flee the jurisdiction is always foreseeable. State v. Sure, which is the case that held that. In that case, I believe a court ordered the defendant to leave the jurisdiction to visit his probation officer in another state, and probation officer arrested him. The court found that there was good cause to set aside the forfeiture on the basis that the Ohio court ordered the defendant to leave its jurisdiction, but noted that the risk that a defendant will depart the jurisdiction is always foreseeable.
So you would disagree with Ms. Kelly's assertion that you'd have to show some sort of history of flight or some other indicia that there was going to be a tendency to flee to make that foreseeable for the surety.
That's correct, Your Honor. And I think the cases in Ohio sound that out. And the State v. Hughes case that Ms. Kelly cited as the Supreme Court case on this issue stated that the risk that a defendant is going to flee the jurisdiction is, quote, a business risk of the surety.
So is there a distinction? I mean, some of the cases that were cited in the brief involve defendants who are incarcerated in a different county in Ohio. Is there a distinction between somewhere else in Ohio versus across state lines?
Yes, there is, Your Honor. And I think you're referring to the State v. Yount decision. In that case, a defendant was being held by another Ohio county. And the court in Yount found that the state can't eat its cake and have it too, essentially. They can't hold him in another county. They can't hold the defendant in another county and then order the bond forfeited in the county in which he's under indictment.
Because it's all the state of Ohio.
It's all police action from the state of Ohio. Exactly. There have been no cases in Ohio that cited that a police action from another state has been good cause to set aside the forfeiture. I know.
I guess where I'm getting hung up, I understand the case law, but I also look at the purpose of bond and bail, and we want to ensure the defendant's appearance in court. And we have a situation here where we know exactly where he is. There's a detainer on him. And the presumption is that as soon as he's released from custody from Campbell County, he's going to be transported to Ohio to face the Ohio charges. So my question is, why forfeit the bond now? Why not suspend the surety's liability on the bond until the defendant can be brought back to Ohio?
Sure. Well, obviously, the state would have preferred that the surety in this matter do more due diligence and prevent the defendant from leaving the jurisdiction in the first place. That was a terms of the conditions of the bond that Mr. Sifu agreed to, that Allegheny agreed to, and that the defendant agreed to.
How would they do that? How would they stop him from going across the river?
I'm not a bondsman, Your Honor. I'm not sure how they operate. It appears to me that they don't really do anything, but again, I'm not a bondsman.
Okay.
As for the holder, I would presume that once his stay in Kentucky is over, he will be brought over. That's my presumption. I don't know for sure. And also, in the meantime, there's going to be prejudice to the case that the state of Ohio is putting on against Mr. Jackson. I understand now that there's still an active case. There's another co-defendant, but we don't know when Mr. Jackson's going to be back. We don't know where these witnesses are going to be when Mr. Jackson comes back. It may very well be that by the time Mr. Jackson is brought back to the state of Ohio, the state's case has been prejudiced so much by witnesses leaving, witnesses' recollections fading, that they won't be able to try Mr. Jackson.
So is this just kind of a punishment to the surety? I mean, is that what we're doing?
Well, Your Honor, the bond contract, the recognizance form states that the state will let the defendant out of jail in exchange for the sureties to prevent him from violating the terms and conditions of his bond. In this case, the state upheld its end of the bargain and allowed Mr. Jackson out of jail. As far as I can tell, the sureties didn't do anything to uphold their end of the bargain.
And one more question on
Sure.
the charges. Did he go across the river and get in trouble that day and get arrested, or were these charges that were pending?
I believe he pled out, and at some point that day or early the next day, he went across the river and was arrested on unrelated charges. I don't believe they were pending at the time.
New charges that the surety didn't know about.
I believe so, Your Honor.
Okay.
Moving on with the impossibility, there are numerous other cases. There are two cases: State of Ohio versus Ohanian and State of Ohio versus Bandelli. Those are both cases where the defendant left the country, and still the courts found that was not unforeseeable, that the surety was not entitled to a defense of impossibility there. So the fact of the matter is, Your Honor, impossibility and foreseeability, those are intertwined together. In order to demonstrate impossibility of performance, the surety needs to demonstrate that this was unforeseeable, and the case law in Ohio is simply that it's always foreseeable. There's no way around it. I know counsel said that there are numerous cases that go against that, but I haven't seen them. They haven't been cited in this matter. As for the position,
Can you give me an example of a situation that's unforeseeable then? Or when a surety wouldn't have the bond forfeited?
I mean, we have the I don't know if I can, Your Honor. I know the State v. Schurer decision, where the court ordered him to leave the jurisdiction to visit his probation officer. That was a case where the surety was exonerated. As for what could truly demonstrate impossibility, I would imagine if the defendant is deceased. I couldn't find any case. I don't know any case law on that specifically.
So there's really not much of a situation unless a court would order the defendant to leave the jurisdiction, that you would, pretty much every other situation would be a forfeiture.
That's correct, Your Honor.
Okay.
What about hospitalization? Is that good cause?
Again, Your Honor, I'm not aware of any cases on that point. I could tell you from a practice standpoint, because I do these bond forfeitures in front of the trial court, if I were presented with that issue, I would likely give the surety. I would likely agree to a continuance for the surety on that basis. I likely wouldn't go forward on a bond forfeiture there. But I'm not aware of any.
Is that just because you're using your prosecutorial discretion of not going forward, or is there any sort of other reason?
It would be my belief that would perhaps be a type of impossibility. And also to give the surety, the objective for the state here is to make sure that these defendants make it back to court. I don't want to forfeit a bond when I believe the surety will be able to promptly return the defendant to court. And if it's a situation where the defendant is hospitalized for whatever reason, I don't have any reason to believe that the surety wouldn't very promptly be able to bring him back.
But you know that in this case. I mean, you said most likely he's coming back to face charges in Ohio once he finishes his sentence, right?
Again, yes, Your Honor, that is my presumption. Again, I don't know for sure. I don't know what Kentucky will do when he's released. Presumably they will send him back over here because there is a holder. However, I think the time frame is significant here. I'm not. It's going to be some time before Mr. Jackson is released. And again, at that point, the prejudice to the state and its case, they might not be able to move forward.
So does that go into our calculation as well? We have to look at how much the state's going to get prejudiced to determine if the bond should be forfeited.
So there are some cases, Your Honor, that set forth a number of factors on when a remission is, when a surety is entitled to a remission. It's the State v. Marks case. One of those 6 factors is prejudice to the state. However, those cases always kind of envision that the defendant has been brought back already. It's cases when the defendant's been gone for a long period of time, but he was picked up and brought back. That's when a court's going to look at whether a bond should be remitted. I'm just thinking forward here. When Mr. Jackson's released, we don't know what the state's going to be able to do in terms of its actual criminal matter against him.
How long's his sentence?
That I'm not aware of.
Oh, okay. Because you were saying it was going to be a lengthy period of time. I just was curious as to how long his sentence was.
I'm not sure. It's my understanding it's going to be a number of years, but I don't know the actual number.
Okay.
There's a holder on him because his bond was revoked, right? And then forfeited. So as long as his bond's revoked, the holder will stay in place. But if for some reason it was reinstituted, would he be released?
If it was reinstituted while he was in the custody of the state of Kentucky, I think in that situation there would still probably be a holder on him, that if he's on bond in the state of Ohio for pending charges. But I don't know the answer to that for sure.
There's a capias issue. There was right?
Yes.
Okay.
And you have 2 minutes left, Mr. Sayre, if you'd like to use them.
Yeah, just let me check through my notes real quick. I might be done. Oh, there was one thing I wanted to add. There was some discussion during Ms. Kelly's arguments about staying the forfeiture proceeding until the defendant is brought back. The only cases I'm aware of that being done is when it's been a police action of the state of Ohio that led to the defendant being shipped off to another state. I'm not aware of any case where a defendant voluntarily leaves the jurisdiction and violates the terms and conditions of his bond where a court has allowed this stay to take place.
Didn't that happen in Scherer?
I believe that is when it happened, actually, Your Honor, and
Okay.
sure. But in that case, the court ordered him to leave the jurisdiction to visit his probation officer. It was a state action of the state of Ohio that resulted in that.
Okay.
And with that, Your Honors, I'm done unless you have any other questions for me.
Questions? All right, thank you. Ms.
Thank you.
Kelly, you have 5 minutes.
Thank you. In Scherer, though, the state action is the fact that he was held in Kentucky. In fact, the facts of Scherer mirror our own. And Judge Krause's question, I kind of was looking at the fact that the court in that instance said temporarily suspend and not do the bond forfeiture until he is brought back. Now, we believe he was sentenced and serving from 2019, and I believe he had a 3-year sentence. So I don't know what good behavior standards are in Campbell County, but I believe that he'll be released around the early part of 2022. And
well, so what about the issue of prejudice to the state? I mean, you know,
I mean, that
would it matter if it's a 3-year sentence versus a 10-year sentence?
I mean, I don't believe it does. I do bond remissions as well. And those 6 factors that counsel discusses, in the reasoning of the factors, I actually never really see a reliance upon how difficult will it be for the state to present its case. I can tell you right now, discovery has just started against his co-defendant because I'm still being notified of the actions on that. So if we look at the fact that he's going to be released in 6 to 9 months versus 6 to 9 years, I think the prejudice to the state's case is a non-starter. He will be out and will be presentable to that. Also,
well, but I think that's my question though. Does it matter whether it's 6 to 9 months versus 6 to 9 years?
I would argue no on a remission. I would argue that at any particular time, a state's case can degrade, and the fact that you're going to tie it to a bond forfeiture again puts something onto the surety that is not recognized under the law. But also State versus Hughes, he was also incarcerated in another state, and that's our 1986 Supreme Court case. So there are cases where the police action, if you will, is incarceration outside the state. It is not just between the counties of Ohio, and therefore the state of Ohio cannot benefit from preventing one of its neighboring counties from producing a defendant. So that, to me, is not the correct recitation of this case law. Also, as far as fleeing the country, a surety worth their salt will make sure that those passports are deposited with the clerk of courts if you have a foreign defendant, which is routinely done. And in these cases, the flight risks, and there's 2 to 3 cases that the state cites in its appellate brief that apply to flights overseas. If they didn't grab their passports, then I would argue surety is not doing their job. And those cases are distinguishable on that instance.
If they use if they use a fake passport, is the surety on the hook then?
Well, we actually had that instance in Franklin County, and no, a fake, the fact that he can make a fake passport, and I mean, you actually, believe it or not, can bust down through Mexico and get out through Mexico very easily. And it is a challenge with these international defendants. And if it is a large enough case, they now put GPS ankle monitoring on them, because that's the way you can ensure that it won't be a flight risk. But as you know, that's a very expensive proposition. So you have to balance that
Well, they
with
can
the
just
charge.
cut those, they can just cut those off.
They can, and we had a murder case where actually they put a PI outside of the guy's house that watched him until
The
his
surety did.
The surety did.
Oh.
Yeah, and charged him back. He was a doctor that was accused and convicted of murder. And they actually had somebody outside the guy's house. Because you're right, they found him trying to cut his GPS monitor off. So it's a strange, a strange but fact-driven situation about what is reasonable under the circumstances. And the surety in this case would ask that this was an abuse of the trial court in entering this bond forfeiture, and that this honorable court reverse that action. Thank you.
All right. Thank you, Ms. Kelly. And that was good timing because you are at your time. Council, thank you both very much for your arguments this morning. We will take the case under advisement and give you a timely written decision.
Thank
And
you.
that will-
Thank you, Your Honor.
Thank you all. And that will conclude this session of the First District Court of Appeals for Monday, May 3rd. Thank you.
Bye-bye.